Before we begin, we'd like to give special thanks to all of our sponsors for making this event possible each year. Specifically, thank you to CRL FormFox for being our title sponsor for 6 consecutive years. And thank you to our platinum sponsors, Psychmedics, OraSure Technologies, Quest Diagnostics, and Veriforce. Hello, and thank you so much for joining us for another session of Day with DISA. Today, we're going to be discussing FCRA and adverse action laws, and for that, we're joined by Morgan Reynolds, DISA's Vice President of Risk and Legal Counsel. Morgan, how are you doing today?
Happy to be here. Excited.
Well, before we jump into the presentation, I do want to remind everyone of a little bit of housekeeping. If you have any questions, use the Q&A button at the bottom right of the player. If there are any questions we're unable to get to today, we'll reach back out to you after Day with DISA. Additionally, we're going to make a copy of this presentation available for download in the Materials tab at the end of the session. With that being said, Morgan, the floor is yours.
Great. Let's get started. So today we're going to talk about the FCRA and adverse action as Thomas described. So that's my bio. I've been with DISA for about 6 years. I'm very excited to be here. I am a lawyer, but I'm not your lawyer. This is not legal advice. Sorry for the disclaimer, but I have to do it. This is all best practices discussion, and we are not forming an attorney-client relationship by being on this webinar. All right, so let me give a quick overview, and then I'll talk about our agenda that we're going to cover today. So basically, there's three main parts of the FCRA which end users, which is you, need to comply with. So let me explain. The FCRA, the Federal Fair Credit Reporting Act, is a consumer protection act. And as part of that, DISA is what is called a consumer reporting agency. And so any background report we produce goes to what's called an end user. That's the client receiving the report for employment purposes. So employers have 3 main areas in which they must comply. The disclosure and authorization. So before you order a report with us, you need to disclose to the person that you're going to do a background report and get their written authorization. I actually did a 15-minute webinar as part of our series in 2023. And if you did not attend that, I highly recommend that you go and watch that. There's a lot going on with disclosure and authorizations, and if you haven't updated your forms in the last year or 2, they definitely need a review and a refresh, and you should review those with your outside counsel or in-house counsel. But if anyone would like a link to that webinar, go ahead and ask in the Q&A and we'll get that over to you. But it's a 15-minute webinar focused specifically on disclosure and authorizations, which is an essential part of the background screening. Before you order it, you need the disclosure and authorization. So the second part is the permissible purpose. So most of the reports that are ordered are going to either have a permissible purpose of employment, so you're considering hiring someone, or site access, where you're trying to get onto like an oil site, a refinery site, something like that. But you need a permissible purpose with which to do the report. And it's not, my neighbor, I just think they're a little suspect and I want to check them out. That's not a permissible purpose with which you can order a report through DISA. And then the final aspect that employers need to comply with is the adverse action procedures. And so that's what we're going to focus on today. We're going to go through the FCRA pre-adverse and adverse procedures. We'll talk a little bit about hiring decisions, and then we'll go into some state laws. And then hopefully, if I'm not too long-winded, we'll have time for some Q&A at the end. So the first question, or the first section here, is what is adverse action? So if you don't know, you came to the right place. So adverse action. So basically, I want you to focus on the top part. I'm not a big slide reader, but I want you to look at this. It's any negatively impactful decision based in whole or in part on information contained within the consumer report. So a lot of times we'll get questions about, I didn't really like this person, but we put them through, and this kind of confirmed my suspicions. Do I need to follow adverse action procedures? Or things like, well, they weren't sure if they wanted them, and this is not really job related, but what do I do here? So I just want you to focus on the in whole or in part. So it doesn't have to be the sole reason that you're not hiring someone. It can be a part that puts it over the edge, and that's a hard distinction to make, and it's one that we get a lot of questions about, like what is in part, but it has any impact on your hiring decision. So you've made a conditional offer, you get that report back, and they have something on there, then you should send the pre-adverse action letter, and we'll get it. You should follow adverse action procedures on the whole, but that will be the first step. So let me go back and explain what a consumer report is, because I was using the term that we use, but it must be created by a consumer reporting agency like DISA, and it would have bearing on a consumer's, creditworthiness, character, general reputation, things like that, and then the permissible purpose aspect that we talked about before. So basically, you get this report back and you consider making an adverse decision on their employment, promotion, kind of anything related to employment. That's when you send the adverse action or follow the adverse action procedures. Okay, so we've talked about employment purposes and that one permissible purpose. As I said, not hiring a candidate would be something under employment purposes. Terminating an employee. So let me unpack that for a second. You have an employee and you consider promoting them, and you run their background, and then they have something on the background which doesn't just impact the promotion, but you decide, well, they're not fit for this job at all. That would be something that you need to follow the adverse action procedures, as we talked about, deciding to demote or not promote, reducing job responsibilities, suspending an employee. So all of those things would fall under employment purposes and need to follow adverse action procedures. So reducing job responsibilities is one that also we get questions about. If you put them, say they're not eligible to drive legally, they don't have a driver's license, it was suspended, and so you put them into a different role, you accommodate that, you still should follow the adverse action procedures, because you're reducing their job responsibilities, even if it has no impact on the pay. Okay, so pre-adverse action procedures. So you order the background report, you get the results, and then ultimately, as we talked about before, you are going to make a decision based upon that report in whole or in part, which would impact the consumer's employment. What do you need to do? It's actually pretty simple. You need to notify them. So you provide them a copy of the report and a description in writing of the rights of the consumer, and then you give them an opportunity to respond. So it's basically you're notifying them up front. This is pre-adverse, and you have an opportunity to explain, like, oh yes, that happened, but I've done X, Y, and Z, or there's a period of a waiting period where you can pause the decision. So you need to notify them in writing. Now, the FCRA doesn't necessarily require the pre-adverse action be in writing, but how are you going to prove up that you notified them, you told them of their rights? There's no pre-adverse requirement that be in writing. It actually does say oral or written, but I would always say do it in writing. So as we just talked about, adverse action procedures, provide oral, written, or electronic notice of the adverse action. But I would fall on the written, being the risk-averse person I am. So backing up, we did the pre-adverse action. So we got something on the report. Let's go back to our hypothetical suspended driver's license, where you're going to use the report in whole or in part to make a hiring decision. So the person has a suspended license and this job requires driving. So, you provide the pre-adverse action letter. You tell them, here's the report that we got from the Consumer Reporting Agency, from DISA. Here are your rights. And then you have an opportunity to respond. So the FTC says 5 days to wait before sending the adverse action letter. It's not actually defined, but we always recommend waiting at least 5 days. So anyway, that's the pre-adverse action. So then you get to the adverse action, and you're going to provide that oral, written, or electronic notice of the adverse action. So this is where you say, I told you about this, and we are now going to not hire you, or not promote you, or terminate your employment. So you're going to provide that notice, typically in writing. And then as part of the adverse action procedures, you're going to provide the name, address, and telephone number of the CRA that furnished the report on that person. And then a statement that the CRA did not make the decision to take the adverse action and is unable to provide the consumer the specific reasons why the adverse action was taken, and they have a right to a free copy of the report. And of course, they have a right to dispute the accuracy or completeness of the report with the Consumer Reporting Agency. So all of that is technically what is required in the letters. The next slide I'm going to show you is going to give you the pre-adverse, a sample pre-adverse. But as we talked about earlier, the disclosure and authorization, if you want to link to that previous webinar, we will provide that. Also, if you'd like DISA sample forms, which you can adopt as your own, we can provide those. These are screenshots of our sample forms that we're going to go through. So there it is. That's a sample form that we have. And this is the sample pre-adverse action. And I would highlight to you in the second paragraph, it's highlighted, it says, identify specific items. So this is a best practice where you identify the information on the consumer report, which is impacting the hiring decision, the promotion, all of that we've talked about. So in some states, it is required that you identify. It is a best practice to identify it anyway. So this is the waiting period, as we talked about, is in the fourth paragraph. It talks about 5 or 7 business days, and we give you some information on where that is. And we'll talk about California later on when we go through the states. We're only going to have time for 2 states, but California is one with a new waiting period. And then finally, a date of when the final decision will be made is important to have in the pre-adverse action. And then here's a sample adverse action letter, which is substantially similar to what I covered in the slide. Basically, the CRA didn't have any role in the hiring decision, the right to dispute the accuracy, and all of that technical requirement. So again, if you'd like our sample forms, you can request that in the Q&A. All right. So those were the technical requirements of pre-adverse and adverse action. Now I just want to spend a couple of minutes here highlighting the hiring decision considerations. So about 12 years ago, 2012, the EEOC released their criminal history guidelines and usage. And that really was a big change for people. But the things that you should think about, and the criminal history guidelines are very helpful in understanding records. Because before that, I'd get questions and it was like, well, is this job related? And that was kind of covered in the EEOC criminal history guidelines. So the things that you want to consider are the nature and gravity of the offense conduct, the time that is passed since the offense conduct and or completion of sentence, and the nature of the job sought. So basically, it's 2024. If you get back a record from 2015, where the person is now in their 30s, but they were in their early 20s at the time, and they've had no additional records, and they completed their sentence, that should factor into your hiring decision, is basically what this is saying. So you consider the job relatedness, the time it's passed, and their good behavior since. Then there's a bunch of state considerations. We're not going to have time to go through all of these. As you can see from this chart, a bunch of states have specific state considerations. We're going to cover California and New York, but there's other states with things you should consider. And if you'd like more information, you can ask in the Q&A, and we'll provide some best practices for those if you see your state here. And the red ones are local laws. So like I'm looking at Florida, there's Gainesville, Florida, there's certain in Texas, Austin, Texas, things like that. South Carolina, Columbia, South Carolina. So basically, like New York, California, and then there's New York City has a specific law with complex requirements, and so does Los Angeles, all of that. So this map gives you some analysis of whether there could be local or state considerations with the hiring decisions. Okay, so California, this is another one. We did a 15-minute webinar earlier or in 2023 on the changes to the California Fair Chance Act. So on July 24th, they enacted a law which became effective October 1. So basically, California went and revamped their already existing fair chance law and had some technical requirements and then some additional new considerations. So in California, when you're considering criminal history as part of a background report, you still must wait until after a conditional offer of employment. Additionally, there's a prohibition to current employees, in terms of waiting until you've made that offer of promotion until you run that. Another aspect is there's an increased wait time for adverse action. So let me take a second on that, because we talked about the five business days on the pre-adverse and adverse under the FCRA as a best practice. In California, there's a technical requirement to wait 5 days after the order, a period of time after the pre-adverse action is sent and confirmed received. So when you send a pre-adverse action through email, there's already in the statute a presumption that it will be received 2 days after you send it, and then you have a wait period after that. And we covered all of that in the 15-minute webinar in 2023. If you'd like a link to that, please ask in the Q&A. Additionally, there's a new definition of an applicant right there. So California made some substantial changes in 2023. The regulations continue to require an individualized assessment. That's substantially similar to the EEOC requirements, an individualized assessment. So you don't have black and white hiring policies. It's just like what we talked about a couple of slides ago, the nature and gravity of the offense, the time that's passed, and then the job relatedness or the nature of the job held or sought. Now, that's the same as you would have seen previously. There are new individualized assessment requirements. Employers must conduct an initial individualized assessment. So what does that mean? What is an initial individualized assessment? It's you look at it, you're not automatically sending a pre-adverse action if they have a felony conviction, let's say, as an example. You look at it and say, is that job related? So if you're sending a pre-adverse action in California every time of anything, then it's probably not going to be seen as individualized. And then there's new initial assessment factors and sub-factors. I think there were 11 or 12 in the statute to consider there. So California, they have the same sort of requirements post offer as the EOC, nature and gravity, time passed, all of that. But then there's all these initial sub factors which you should consider. All right. Last section here. Moving on to New York. So this is New York State. New York City has a very technical requirement too, but we're just going to focus on New York State in this presentation. So New York Article 23A, it applies to both public and private employers. Employers must review the conviction history and then look at the job relatedness and compare it to the specific employment sought or held. So like using our hypothetical of the motor vehicle report comes back, they're not eligible to drive, but perhaps the position doesn't require any driving, then maybe you wouldn't consider that and not send a pre-adverse action letter. Then you also consider whether it's going to cause a risk to the welfare of the general public or specific individuals and compare that. So there's a number of considerations within 23A. There's the public policy consideration where, and this is where you need to really understand like the reason for the law is that they want to encourage employment of people who've been convicted of criminal offenses. So the public policy is like, hey, err on the side of giving people a second chance. Then as part of that, you want to consider the responsibilities, the time that's passed, the age of the person. So using our previous hypothetical where they were 24 and now they're in their 30s and they haven't gotten in trouble again, that might be something. The seriousness of the offense or offenses, was it a misdemeanor, was it a felony, things like that. Rehabilitation, and then the risk to the public. So that's Article 23A in New York. And as part of your pre-adverse action, you need to provide a copy of that. We have all the sample forms if you need that. All right, so we talked about disclosure and authorization very quickly. We did a 15-minute webinar last year. Please review your forms, review your forms. That is a high risk area for employers right now. We talked about the hiring decisions and sending the technical requirements of a pre-adverse and adverse action letter. We talked about some state law considerations. So now, Thomas, let's move into the Q&A.
Lots of great information. We do have a couple of questions here. First question, if I'm hiring a remote employee, does this change anything?
Absolutely. And that's a great question. So I can't answer specifically what it will change, but it absolutely will change the state law implications. So if we refer back to that chart that I had showing the different states, if you're hiring for a job in Texas and they live in California, and they're a remote employee, then you're going to need to follow California law. And I would, this is not legal advice, I would review that with your HR professional, outside counsel, in-house counsel, but which laws impact the hiring process. But that's a great question. And it's a hard question because, previously there weren't a lot of remote employees. And so it would be like you're coming to work in Texas, the job's in Texas. So people would kind of fall back on like that, using Texas as an example, or Ohio, Florida, whatever, But now you need to consider where the person's going to live when they're doing the job, and remote employment does make that significantly more complicated. So that there does need to be an analysis of the state or local laws, which would impact that.
Got it. If a candidate has falsified previous employer information, do we use the adverse action process to deny employment?
Okay, so let's go back to our question or our discussion about in whole or in part. So the consumer report is providing you the information that they falsified, the job information. So you're using that in part or in whole to make a hiring decision. Now, it's the falsification or the lying on their resume that's ultimately causing the hiring decision, but you should definitely provide a copy of the report, follow pre-adverse, give the waiting period time. So yes, you should follow pre-adverse and adverse action procedures.
Okay. If I send the pre-adverse notice via physical mail versus email, does that change the waiting period for how long I need to give a candidate to respond?
Okay, I'm going to give a very a lawyer answer here, but it depends. It depends on the state law implications. So in California, it's in the statute that yes, it changes because there's a presumption within the statute unless you send it via overnight where you can confirm the receipt. There's a presumption that you need to increase the waiting time for receipt. So I get this question a lot, and it really it's an email it gets there immediately, right? But people don't have to, unless there's a state or local law implication, you don't have to extend it. I think it's a good practice to make sure you give the person time to respond, but you're running your business, you have other, priorities, but you want to get them a copy of the report and an opportunity to respond. So if you're sending it mail and it's going to take 5 days to get there, or 3 days or whatever, then maybe you do add it on. Most people now are sending it electronically, or we have clients who send it overnight, and so that they can see that it was signed for and delivered, things like that. It's not required under FCRA to give more time, but there are state and local impacts on that.
Got it. What's the most common mistake that people are making during the adverse action process?
The most common mistake. Oh, a lot of good questions today. So I would say the waiting period and not considering local or state laws on increasing the wait period from 5 days, or telling people internally, which is ultimately discoverable. Okay, we're moving on from this candidate after sending the pre-adverse, but not waiting the 5 days. Like this person's not marking your HRIS as not eligible for hire as soon as the background report comes back with something. Things like that. Whatever you do where it looks like a final decision has been made prior to following the pre-adverse and adverse. Those are the major missteps I see.
Okay. Are there new laws coming in 2024 that will change adverse action?
So, I mean, another very good question. California really kind of leads the way, I would say, in a lot of this. So if you go back to the discussion of California and the new law that was enacted effective October 1, with the increased wait time, with the individualized assessment, sub factors, all of that, I think you'll see some states kind of follow that. We've seen that in other aspects that California, in certain areas, other states will follow them. It's an election year, so there may be other focuses with the state legislature, things like that. I'm not an expert on political science and all that, but I think you'll see something this year. Yeah.
Great. If the applicant withdrew from consideration, but they have records on their report, do I still need to send a pre-adverse action letter?
So that's going to be a fact-based analysis of whether or not you gave them any implication that they were potentially not going to be hired based on, in whole or in part, the background report. Generally, if they say, you make the conditional offer, you order the background report through your consumer reporting agency, through DISA, and then they say, "Oh, I got another job, I'm out." Like, no thanks. Before you get the report back, then there's no need to send the pre-adverse action an adverse action letter. If you get that report back and then you call and say, "Hey, I need your number because there's something on the report," and they say, "Well, actually, I withdraw," then I would err on the side of sending the report. So it's just a fact-based analysis of if they actually withdraw before the report is even considered, then I don't think you need to send it.
Okay. What about contractors? So if they're running the background check and they get a hit for when they're hiring a contractor?
Absolutely. That's an employment purpose under the FCRA. Contractors, while they may not be considered employees for payroll purposes and things like that, you need to send you need to follow pre-adverse and adverse action procedures.
And then last question, I know we're tight on time. Does DISA help support the adverse action notice process?
Yeah, we will provide that as a service, and there's different processes depending on the platform where you're ordering, but there is support available to help with this process.
Wonderful. Well, Morgan, again, thank you so much for being here with us today and sharing your valuable time.
Thanks for having me again, Thomas.
Absolutely. And to everyone that attended, again, thank you for attending Day with DISA. We look forward to seeing you in other sessions throughout the week. Goodbye.